Talk Shoe. Recorded live.
All right, welcome everybody to NTT, New Trust Technology, Making Payments Under Trust, which is merging titles and extinguishing debt. This is our regularly scheduled The Free Americans Talk Shoe cast, and my name is Matthew, and I'm your host. Before we start tonight, I'm going to read our Notice, Acknowledgement, and Agreement. The show under document is private and not to be construed or relied upon as being legal advice for an individual legal situation or employed for making legal decisions. You will not use any of this information for making a legal decision or performing a legal procedure, and is not a substitute for legal advice and or guidance by a licensed attorney. This private show and or documents are for academic, informational purposes only, to be used at your own risk without liability to Christian Walters. By accessing or reviewing the show or using the documents therein, you understand with agreement that with all rights reserved without prejudice, Christian Walters is not an attorney licensed to practice law in the state of Florida or any other state, and has not given legal advice or accepted fees for legal advice, provided no assistance, advising, or guidance of any kind for use by non-attorneys or pro se parties in the preparation or use of the herein reference, and has no interest in any issue referenced therein, and is not a party to this or any action arising from, and is only acting in an authorized capacity of liaison to communications between the parties. By reading and or using this information, you acknowledge and agree that you are not a client of Christian Walters. These documents and or show recordings are incomplete and void without this notice agreement being attached herein by reference and the breach of this agreement. Upon breach of this agreement, the breaching party becomes liable for admiralty commercial damages of $100 million or more, for stultification or impairment per Christian Walters' discretion. Thank you for your understanding. Our text we're reading out of is a practical treaty on the law of trusts, and that was written in 1888 or published in 1888 in Volume 1 and Volume 2. And we are starting on page 504. And if you just bear with me for a sec, I'm going to pull that up on my computer here. And we'll jump right into it. See if I can find it. Okay, well, I found Volume 2. But I think we're still in Volume 1, so give me another second here, see if I can find that other one. Here we go. Coming up now. And let me scroll down to page 504. Almost there. Okay, we found it. Page 504, we're talking about renewal of leases. Section 7, by another act, also passed 20th August 1860, where any estate or interest under any lease or grant from an ecclesiastical corporation is vested in a person as trustee, whether expressly or by implication of law, with a power to raise money for procuring a renewal, or where such power is vested in any person. Excuse me, I just got distracted by my phone. It is made lawful for any such person to raise money for the purpose of purchasing the reversion or otherwise enfranchising the property. And it has been held that this enactment confers a power not only to raise the money, but also to effect the purchase or enfranchisement. But this will not authorize the trustees to make any arrangement with the revisioners which will disturb the relative rights of the tenant for life and the remaindermen under the settlement. And where it was proposed to surrender part of the leaseholds in consideration of a release of the reversion of the rest of the leaseholds, and the interests of the tenant for life would suffer by the arrangement, the court had no power, without the consent of the tenant for life, to give effect to the proposal, though beneficial on the whole. Section 2, how fines on renewals to be levied. We next proceed to inquire in what manner the fines for renewals are to be levied by the trustees. Upon this subject, we shall avert first to the case where the settlor himself has specifically marked out the fund from which the fines are to be raised, and secondly, to the rules adopted by the court where the settlor himself has omitted to declare any intention. Page 505. First, where the fund for the fines is pointed out. Number 1, how to be levied out of rents, issues, and profits where the leases are for years. If there were to be an express trust to provide the fines for renewals out of the rents, issues, and profits, and the leaseholds are terms of years not determinable on lives, so that the time of renewal can be certainly ascertained, it will be the duty of the trustees to lay by every year such a proportion of the annual income as against the period of renewals will constitute a fund sufficient for the purpose. Number 2, fines to be levied out of rents and profits or by mortgage. If the trust be to levy the fines for renewal out of the rents issued and profits or by mortgage, it was held in a case before Sir J. Leach that the annual rents only would in the first instance be applicable, for he considered authority to mortgage not as making it optional with the trustees whether they should or not affect the interests of the remaindermen by throwing the charge of the renewal upon the corpus of the property, but as given for the protection of the City K Trust in case the amount of the fine should not be otherwise forthcoming. B, and intimated that should the trustees be under the necessity of mortgaging, the court would call back from the party in possession the amount of the encumbrance thus temporarily incurred. C. However, in the later case of Jones v. Jones, B, where the trustees were empowered to levy the fines by and out of the rents, issues, and profits or by mortgage or by such other ways and means as should be advisable, the court, after observing that to levy the fines from the rents would throw them on the tenant for life, while a mortgage would be oppressive to the remaindermen, declined to give any opinion whether the trustee might not, had they exercised their discretion, have determined upon whom the burthen should fall. But as the trustees had not exercised their discretion, it was held that the court could adjust the onus amongst the parties according to the equitable rule. in proportion to their actual enjoyment, as soon as it could be ascertained. And in Greenwood v. Evans, Reeves v. Creswick, and Ainsley v. Harcourt, where the fines were to be raised out of the rents, issues, and profits or by mortgage, the court in like manner adopted the principle of throwing the onus on the successive tenants of the estate in proportion to their enjoyment. In the first two cases, the leaseholds were for lives, and in the last, the leaseholds were partly for lives and partly for years, but no distinction was taken on that account. The present leaning of the courts would appear, therefore, to be to consider the language of the instrument as directing only the temporary mode of raising the fines without prejudice to the ultimate equitable adjustment according to the principles now acted upon in equity in ordinary cases. But if the trust to pay the renewal fines by and out of the annual rents and issues and profits with a power, if the money wanted for renewal be not produced, to raise it by mortgage, the onus will fall upon the tenant for life. Number 3, how to be levied when the leases are for lives. If the leaseholds be either for lives or for years determinable on lives, and the trust is to raise the fines for renewal out of the rents issued and profits, the expenses of renewal must still be cast upon the annual rents, if it clearly appear that such were meant, though from the uncertainty of the time the trustees cannot be sure they shall have accumulated an adequate fund. Number 4, whether rents and profits means annual rents. But the expression, quote, rents, issues, and profits, end quote, often stands by itself without any sufficient indication, aliened that annual rents are intended, and then the question arises and is attended with great difficulty whether the fines shall be raised out of the annual rents or the corpus. Page 507, Stone v. Seed. In Stone v. Seed, Lord Thurl held that annual rents only were applicable. In Allen v. Backhouse, Sir T. Plummer considered that the trustees might sell or mortgage, and that the tenant for life and remaindermen must contribute in the usual proportion, and this decision was affirmed on by Lord Eldon in Shaftesbury v. Marlborough. Sir J. Leach observed upon the conflict between the preceding cases and followed the authority of Lord Thurlow in regarding Barber's settled estates. The authority of Allen v. Backhouse was conceded without argument. The decision in Platers v. Abbott and Townley v. Bond must be viewed as resting only upon the special wording of the instruments which were under consideration. The decisions in Platers v. Abbott and Townley v. Bond must be viewed as resting only upon the special wording of the instruments which were under consideration. In Greenwood v. Evans, Jones v. Jones, Reeves v. Creswick, and Ainsley v. Harcourt, the trustees were empowered to levy the fines for the rents issued in profits or by mortgage, and the court, as we have seen, apportioned the burden amongst the successive tenants according to their enjoyment. 508. Results of the cases. The result appears to be that where the direction is to raise the fines out of the rents issued in profits, simply the court may be compelled by express language of the instrument to throw the fines upon the annual rents, but will lean strongly against such a construction. Oh, here's Christian calling me once. All right, folks. Thanks for holding. Christian did call me, and apparently they're having a power outage down there. But what Christian has told me he'd like to do, if it's okay with everybody, is we're going to put the reading on hold, and we're just going to open up the call to questions. So if you have any questions, now would be a good time to start preparing for that. You can go ahead and hit *8 on your phone, and that'll show up in my queue showing me that you do have a question. Looks like somebody already hit *8. And we will go ahead and open the lines for questions here. It's just going to take another second for Christian to dial in, and as soon as he does, I will unmute Christian so he can go ahead and answer your questions. And I'm going to just annotate here that we did read 3 pages and that we will start back up on page 507 next week with our reading material. So thanks, everyone, for your patience tonight. And as soon as I see Christian jump on the line here, we'll go ahead and open up the call here for questions. Christian, is that you? You just unmuted somebody from Florida. All right, just another second here, and we'll go ahead and get started as soon as Christian gets on the line.
Is Christian on yet?
You know, I'm keeping an eye on my screen here for him to jump on, and not seen him yet. I expected him to be on the call by now. I know he was going to be dialing in from his cell phone. Let me just switch over and just make sure that he's calling in. Hold on a sec, folks. All right, folks, we got Christian on the line, and I am unmuting him now. Christian, can you hear me? Are you there, Christian?
Yes, I'm here. Can you hear me?
All right, yep. Great to have you on the call. Welcome. We do have a caller already unmuted, ready to ask this question from New Hampshire. So, caller from New Hampshire, go ahead.
All right. Hi, Christian. This is Timothy. Last time I called, I talked to you on Saturday night about the hearing that was coming up on Tuesday.
Uh-huh.
I'm in Vermont. I'm actually in New Hampshire with an actual phone and high-speed internet. Nice. But anyhow, I'll tell you how the hearing went. I went into the courtroom and came up before the judge and went before the bar, and they called my name, and the lawyer came up, and I went through basically Timothy Forrest, said, my name, grantor in fact, this hearing is contrary to equity and trust. Went through the whole piece, and I repudiated the repudiation and ordered the trustee to extinguish the debt. I pointed to her, and she would be in breach of trust. I gave her 3 days to settle the account. And it was like I was talking into a wall or nothing. And so every time they would address me, I said that full statement again. So I must have said it probably upwards of 10 or 13 times, in the course of an hour or more. And my thought afterward, because he just rolled right over it and entered the guilty plea and made the fines, and in order for me to get out of the court, I had to pay my father paid the fines because I didn't have enough money, basically. And so now I've come up and written a letter to the court, and this is my next step, which I'm creating basically, that all to send into the court tomorrow, because there's a 72-hour time period at which they gave me to a notice to appeal. And in that letter, basically, I said yesterday there was a hearing for the defendant Timothy, all caps fiction. I visited said court as the grantor in fact. When the case was called, I came forward into the foreign jurisdiction under threat and coercion to express myself as a grantor in fact. I also made known that the hearing was contrary to equity and trust, that trust was a special matter, and that there exists no remedy at law. I invoked the private side of equity for relief. Specifically, I repudiated the repudiation to perform by the prosecutor and further ordered her to extinguish the debt and provide me access to due process of law. The court ignored my demand, order, and thereby defaulted. Now, I didn't, if I were to go back, I would say this court is in default. What I would do next, whether if I walked out, I tried to walk out earlier, and they, said, you got to go see the clerk, basically. I'll continue reading. Thereby defaulted on the trust, and is furthermore in breach of said trust. Prosecutor has been given 3 days to settle the matter or be in breach of trust. I was handed a notice of appellate rights, which gave me two options, 30 days for Supreme Court and 3 days for a jury, 12 jury people, basically. This court has put on notice that it is in breach of trust and that I demand the issue to be pressed through equity on the private side, which was not an option given. I have openly in court stated several times that the matter repudiation brought forth by the prosecutor has been reputed and therefore is, quote unquote, dead in law. I do not seek one or of the two options set forth in the court notice. I demand a private court of equity to settle this instant matter and provide me my right to due process in law. Trust is a special matter, and the res has been pulled from general deposit and redeposited in special deposits, thereby changing the nature of the court. If the court chooses to ignore this letter, it will be in breach of trust and open to a counterclaim. Please contact me with a date for a case in writing in private equity post haste, or come to me immediately to make me whole again and undo the damage to me in propria persona. And that was signed grantor in fact. That's to go out tomorrow. My question is to how to go about what can I expect from the court, for one, when they get this letter, and two, how can I make follow-ups? And I'll be quiet now.
Well, it sounds like you did pretty good so far, except they rolled over on it.
They rolled off. But the judge, I looked at the judge, and I was smiling, and his hands were just shaking as he was writing on, and, it's like, I touched the point. I touched some point anyway, but he wasn't, he certainly didn't acknowledge anything that I said. And the first time, I told you about the first time I was thrown in front of him, I basically, he just said, you're insane, or you need professional help, because I wouldn't grant jurisdiction. And I don't know. I'd like to be able to go through with this, though. I filed a tremendous amount of papers to the International Court of Justice, to both attorney generals, to the governors. But the prior to Saturday, I was working in the debtor-creditor realm, and now I'm working in the trust realm, which I'm somewhat familiar with trust, but I have got a long ways to go, and it seems like that's the better route. I mean,
so this is a letter you're going to send to who now?
To the clerk. The court clerk. And I was going to bring it in and hand deliver it and have her stamp it or, what do you call it, with her embosser and give it back, certify the receipt of it. At the top it says notice to agent is notice to principal, and notice to principal is notice to agent. All parties involved in case number, and it shows the docket number.
That would almost be like a notice of a hearing and a request for a date for the hearing.
Mm-hmm. Request for.
And you might. Let's see.
I'm coming in as the plaintiff now.
Yeah, it's like you kind of probably have to separate this out into two, the private side and the public side. The public side would be maybe a request for, or not request, a motion for a hearing date to be set.
Okay, motion for hearing date. Mm-hmm.
And then the private side would be the letter rogatory, which might be some of the more private stuff that you got in that letter there.
I see. Right. And so put it as two pieces of paper.
Yeah, like two separated out so that you've got a public motion setting a notice of a hearing date.
Yeah.
Setting a hearing on it, and then that private letter rogatory going into the judge on the private side.
Okay, and address the judge. And put the elements of that, this letter. Uh-huh. And
then it would probably have to be also, that would be setting a hearing. Then you'd probably have to come in as a counterclaim, which that would be breach of trust then.
You're right. Come in as counterclaim. And, well, this is just a letter, so the counterclaim would be next. And should I put a time frame on the letter for them to respond to me? 10, 20.
The letter that goes into the judge?
Yeah. Because I've written so many letters on this issue of being pulled over for a taillight and thrown in jail because I asserted my diplomatic immunity, basically. No one has responded. It's been a month, and
yeah, I would put a time limit for them to respond on the private side as well.
All right. And to follow up with the prosecutor, I sent the trust res with a letter repudiating the repudiation and the special deposit on the trust res registered mail to her. Now the next step, so she was given 3 days. So the next step is to issue a notice of default.
Yeah, she was given 3 days, an opportunity to cure. Maybe that in court there was really the opportunity to cure, so we already gave her 3 days opportunity to cure right there.
I did, right. And
so I would say it would just be a notice of a breach at that point.
Okay, notice of breach.
To the
prosecutor, yeah.
Yeah, to the trustee.
Right. Okay. And to follow up with the notice of breach, I'm going to be doing the UCC filings, and obviously, when does the trust indenture come in to all of this?
Okay, that's what I was going to ask you next. If you had the UCC filings set up so you could prove the trust.
Well, that I hadn't had that before because I found, a friend called me on Saturday. I sent a letter to my friends and families and whatnot, and he sent me back and said, "You're gonna end up in jail. You got to, do something different." And that was when I listened to your call on Saturday, and started all of this. I mean, I've been primed for it. So,
all right, you need to take the case, the bill or whatever the charge was for the ticket for something that they gave you.
Oh yeah, I did that. I made it into a trust res and registered mail to the prosecutor. And
okay, all right. So
she'll get that by Friday.
Okay, then I would do the UCC ones to claimant and the county recorder, and then the UCC 3 and the county recorder. Those UCs in the counties being notices that you formed the trust.
Okay.
Attach those copies of those to the counterclaim.
Okay, that's to go with the counterclaim. Got you. All right.
Now those are just notices. Do you have a green card that they got?
I will have.
Okay.
I mean, I haven't. I mean, this is all.
That's the private evidence that you need the hearing for, the in-camera hearing, to come in and give proof for the trust.
Right.
Hey, Christian, this is Matthew. I just want to jump in real quick because a previous caller had asked, right where you're talking about with the green card, asked the question. He sent this stuff in, but when the green card came back, it was not signed, and he was curious about that. He was wondering why that would have been able to come back to him not being signed, and can he use that as evidence if it's not signed?
Yes, he can use it as evidence, yeah. And any mark on there is a signature. But if they didn't put a mark on there, I suppose that constitutes a signature also. The fact that I got a green card back, the green card is proof that it was sent there.
Right, especially if it's registered.
Yeah.
Because they have to go through certain protocols, and they have to be locked under key, and have to be hand-delivered and different things like that. So.
Right.
All right, I'll jump back off.
So the trust indenture goes in with the in-camera or the private hearing side.
Well, what instructions did you put with the ticket or that special deposit you sent back to the trustee?
I have a letter, and let me pop it up here.
Did that say that they were to extinguish the debt, and that was trust?
I'm sending you this merged titles and titles, and it has the state of whatever plaintiff defendant's complaint for special deposit order for equitable title, and that's the registered number, reference trust account, that's the all caps straw man, followed by the Social Security number without the dash of the trust res, signed by the undersigned grantor in fact. And that's my name. I'm appointing you, blankety blank, trustee on said trust. You are ordered to withdraw all general deposits and redeposit as special deposits, as there is no controversy in this matter and that there is no adequate remedy at law. I'm ordering you to extinguish and settle the matter. Further, I'm repudiating your repudiation and order you to extinguish all debt related to this case. If you do not extinguish the debt within 3 days upon receipt, you will be in breach of trust and liable for a counterclaim.
Okay, that was an indenture right there.
That's an indenture.
Uh-huh.
Okay. Well, that's good. I've covered that, and that letter goes in with the counterclaim to the private side on the judge. Now, see, I was served on by the sheriff on Monday. I mean, they're hammering me from all sides because I've opened up a bee's nest, and as I say, I've really shaken some whatever. But so I got 2 summons, and I did the same thing, the same letter with each one of those, and there's liable to be an IRS agent coming for me in mid-September, and I'm saying, bring it on, let's have at it. So I'll have lots of examples to go by. But I have to get this process down of how to bring it into equity in the court, and how can you call that up at the court of chancery when they're masquerading at law all the time.
Well, the counterclaim itself is an equitable claim.
Yeah.
So you need some kind of a motion put together with it that reflects this counterclaim. And the counterclaim is that, you got a trust. Here's the intent and purpose party specific res, the method of delivery. So that will be proving the trust.
Yep.
And I forget which call we had. It was last week. It was Marshall came on with that book that he found. I forget which state that is. Well, we were talking about how to put a pleading together for equity.
Right.
Because that's the book. That's all the book is all about, how to put a pleading together for equity.
That's what I got to get. If maybe somebody on the call tonight could.
Yeah. Do you have Skype?
I do have Skype, and I'm on it as Tree Hugger, something like that.
Skype Faith to Trust.
Okay, I'll Skype Faith to Trust and have her get me that book.
Yeah, it's FAITH, the number 2, and Trust, TRUST.
Yep, I have it right here. I'll do that right now.
Yeah, well, right now we don't have an internet connection, so.
Okay, I won't do it right now then. Oh, you must be having a tornado down there.
Well, supposedly they're working on the lines. They got a cable blackout.
Yeah, we had quite the hurricane, but it didn't really hit here. We heard about it. Yeah.
Okay, but that book was, when she gives you the tape on there, we talked all about how to kind of lay a pleading out for equity.
Yep.
And we kind of went over the basics of how to put the introduction where it's going to be the facts to establish the trust.
Right. Well,
And
I will get right on that. And
then you got to put your attachments of the UCC filing, UCC3,
yep.
which is just a notice that the trust was formed, and that's pointing to on the private side, and on a private side for the in-camera hearing will be the green card that they got the trust res, along with your original that you sent the trustee, or a copy of the
original, that trust indenture letter.
So now you got the indentures, got the intent, purpose, parties, and the specific res, and the green card was the method of delivery by mail.
Right.
Trustee's got trust res. He's got instructions.
Yep.
And then you probably want to include your copies of your copy of the notice of breach.
Right. Breach.
So then you've got this pleading for the counterclaim for the breach of trust as being the cause of action. Another motion for a hearing to be set.
Yep. Motion hearing. Yep. And this is all after the letter goes into her. And with a
Yeah, and then send that letter by. Have you been using a notary to send that? Have you sent anything on the private side to the judge at all?
I did send a notary in fact on the land, or yeah, I think that was and that was the letter rogatory that I sent to the judge.
By notary.
By notary, but most things I've been sending certified or registered. I could send on the private side the letter rogatory by a notary, in fact, on the land, not notary publics.
Yeah, I would have the notary send a mailing to the judge. That way, you've got another
witness.
Yeah, another witness that you sent it.
Yep.
And have him send it, registered mail also, green card. So you paid the fee, you said, the fine, you said?
Yep, my father did, and oh yeah, I mean I'm out $2,000 on this one. I mean with the bail, I got thrown in jail for 2 days too, and I had a statute Staples security agreement on file with the Secretary of State and something in the sheriff's office and whatnot. So, and there were big fines attached to those penalties for incarceration, assault, kidnapping.
Well, I include a bill that should also be extinguished with it also.
All right, I can do that because they've all been noticed as to what I charge for those folks that are moving beyond the law with me.
Yeah, you're right on the point of stuff we're trying to bring out and work out. So it's like you're right on the cutting edge on the wave here with this.
Yeah, no, as I say, there was a spiritual element that came in on Saturday because I was ready to leave the country, like get in the woods and go to Canada, and I got this call, and because I had exhausted every option, and they just weren't responding to the abatement, to the notification of reservation of all rights, and if I didn't show up, they were going to, I'll show up for the fiction, issue the arrest warrant, and then I'd have to, how would I be able to deal with the other 3 summons that are coming? Just like, yeah. So this definitely is right where I need to be, and I know that. And I'm completely in awe and grateful. And I truly believe that that the latches that are brought into court, there's got to be a way that they're going to follow them. And that latch is repudiation. And repudiating that repudiation, because that's all they got. They're just giving you a bill. And, we just kind of take it.
Yeah.
So I'm going to include a bill to them for all of this.
Yeah, include a bill to them and tell them to extinguish that one also.
All right.
Are you in the Skype group, Welcome to NTT?
I did. I actually got it online to Skype last week too. Okay.
All right.
But I'm having a hard time. I guess your wife, she sent me 20726 money banking and lots of things on a document that I can't open, and I have no idea. I've tried to download different programs that would open it, so I'm not sure what she's using to. They seem to be partial, but now that I have high speed, I can download things. So when you guys are back up, maybe I'll try it again.
Yeah, Skype her again, and then we can resend them, and
okay.
Maybe they'll be complete where you can open them.
Yeah, and my friend is also emailing me, or not Skyping me things. I got the jurisprudence, or what's it called, Judas Dictionary, and I'm going through that, how to put together a case and pleadings, and but I would like to have more information on trust. And as I say, I'm on a crash course. So.
Well, there's plenty of material for that on audios, starting on 11/7 of 2009 and forward. So.
Yep, I'll do that.
With 4 calls a night, or 4 calls a week.
Yep. All right, Christian. I'll let somebody else ask a question, and I appreciate your time.
All right.
How do I log off?
Matt will get you.
Okay.
Buenos. Hello?
Yes, hello?
Oh, okay, great. Christian, I've got 2 questions. This pertains to a declaration of trust and one titled Declaration of Nominee Trust. Is there a difference between them?
Declaration of trust and declaration of nominee trust?
Yeah.
Declaration of nominee trust. You've got two of them there? What are the differences?
Well, in my mind, I'm thinking that go ahead. Go ahead.
Yeah, the declaration of trust, that's formation of a trust, but then if there's a nominee trust, I'm going to assume that is somebody's been nominated to form a trust on behalf of, say, the trustee. Now, there are things like that already because there's the warranty deed in some states that's being recorded into the county on property. There's a grantee, that's a trustee, and there's a grantor, the one who's selling the property. But I was just reading today in Corpus Juris Secundum on the trust section that there are times when the trustee can form a trust for the grantor, as long as the grantor signs the documents. And that's exactly what it is in these county recordings on these warranty deeds. Actually, the trustees forming the whole thing, but the grantor signed it. So I'm assuming that this nominee trust would be somebody's nominated, like so-and-so, and then when he forms the trust, he becomes the trustee. So that is your nominee trustee.
So the same person that is nominated, it becomes the trustee.
It sounds like that could be that way, yeah. And that's the same way what is happening in the warranty deed in the counties here in Florida. I know that for a fact. Because you sign the mortgage, you're the grantee or trustee on the thing. You're doing all the paperwork or having all the paperwork done per your instructions. The property's been signed, the sales contract's already been in place, and then you record you have recorded by the bank this warranty deed, which is the grantor, the seller, and the new purchaser is as grantee. So it's in effect you were nominated as trustee, but you're not trustee until you form the trust. But as long as the grantor signed the trust deed or the indenture, then that's the formation of the trust.
Now, what I want to do is make a declaration of trust. And can you give me an example of how you would write one?
A declaration of trust?
Correct. What I'm thinking is, how much of the corpus body do you have to write inside the declaration of trust in order not to put it back into the public or give out the indenture of any sort?
So it's a declaration of trust of the undersigned and then the real man's name, hereinafter grantor/settler, of this confidential relation expressed, revocable, private trust, modifiable from time to time, is competent with age of majority and power to choose and have unalienable right, title, and interest without granting a waiver of any right, relief, remedy, or defense. Now comes in good faith under 1776 AD law form with the purpose of all laws of nature and of nature's God. Specifically instructs and specially orders the following upon receipt. And then you can fill in with the rest with what you're instructing and what you're going to order.
In a declaration of nominee trust, or even the declaration of trust, is it wise to put in, say, a couple of beneficiaries, their names?
Yeah, you want to make sure that you got the elements in there, which is you got intent, purpose, and I just spelled out purpose. Purpose was all laws of nature, and of nature's God. So that contains the purpose. And it defined the grantor as being whoever the real man is there. So there's one of the parties. So now you'd have to specify the trustee and who the beneficiary would be. That would take care of the three parties. And then this is also the intent, because it's my intent to form a trust. And I said this is a declaration of a trust. And I also said it was a confidential relation. So that's intent, purpose, parties then. And now then you'd have to define what the specific trust res was. And then say how you were going to, say, deliver it.
Okay, and should any more other than what you stated, like where you would state a little bit of the indenture of the trust, how it's going to be applied and how it's going to be processed. Should that be in there also?
Well, that would be expanding on, say, for a specific purpose. And that specific purpose I would use would be for, say, extinguishment of debt and obligations.
The declaration of nominee trust would be pertaining to a trustee creating the trust and naming the settlor, right?
Yeah, the intent is to grant an equitable asset, original segregated special trust res, deposited for a specific purpose in the past, say, and now being held by the trustee for the benefit of the beneficiary.
See, where I was getting a little bit confused is if in the declaration of nominee trust, if the trustee, which all of them are going to be me, I'll be the trustee creating or declaring, I should say, the trust and naming the settlor, which would be the 14th Amendment, or possibly, no, not the 14th. It would be the life breathing man, and as I go through that, supply a little bit of information as to not just the formation, but also the wishes that are going to be applied in the trust, and naming a beneficiary and signing as a beneficial owner at the bottom. Would that work out, or do you have to be the trustee at the same time?
Well, like I said, the trustee can form the trust, but it's got to have the grantor's signature on it.
Okay. See, the problem, I think, where I'm getting confused is that, and I don't want to confuse the vendor that is going to receive this, is that there's a 14th Amendment person, all right? There's the registered person, and there's which is going to be the grantor of all, and the life-breathing man is, of course, the grantor, and you're going to have also the commercial person, the one operating in commerce, and of course that would be the SSN number. What do you think?
Well, that's the only thing that they can see on a public side is going to be through a straw man or some kind of agent. But now, is this going to be a private trust or
private?
Well, if it's private trust, then it's just the parties the way they are, and they're not straw parties. They're just they're real men and women. But if this ever gets seen in the public, then they're going to construe the real men and women to be straw parties. So.
In the nominated trust, they're going to construe them to be
So
parties?
if I'm forming a private trust, I don't have to worry about straw parties then.
Okay.
So why bring them in an issue?
All right. That's where I was hung up a little bit. Sometimes it's good to talk to someone, at least like a person like yourself, because when you have to know what you're doing, know who you are, of course, but separate the three different persons that really make you in the system.
Yeah, it's knowing who you are as grantor. Yeah.
And the settlor will always be the grantor, right?
Yeah.
Okay. Well, got that straightened out, and I'm ready. That was easy. What I was interested in also is the question of whether I'm giving out too much information of the trust if I supply a little bit of information of the, I suppose it would be the...
Well, it depends on whether you're trying to get somebody into a trust or whether or not they really want to divulge that they're getting into a trust to them.
No, it's just really declaring the trust, and then...
I mean, if there's no reason to be kind of sneaky about it, then I could go ahead and put in everything I need in there, put in a full-blown indenture, and everything is up, and I can come out and use trust terms, and there's really no fear of them for that. So,
you see, the documents are going to be addressed to the private side, the American side of the. I hate calling them vendor, but that's really what they are in many cases. But that's who I'm addressing is the American side, the private side.
right.
Since these people all wear two hats, and I guess you've got to make that declaration that you're talking to and only to the American side of whatever they're doing, whatever their department does. But the declaration of trust, I was just wondering about that. How much information do you give? Like you were just saying a while ago, you said to give out the indenture. But I think, I don't know. Is that what you meant? You can even, give out the full indenture of your trust?
To the trustee, yes.
Oh, to the trustee. Now, when the trustee is really the 14th Amendment person, and they are the American side, all they do is process the documents and and fulfill your request, then they shouldn't really need to see your indenture, and which you could always change, after the fact.
Yeah, if you can say it can be modified from time to time.
So even if they were sneaky enough to want to know everything, I can always modify it. Okay. Well, that was a big one for me. Sometimes we get snags, I've noticed. I'm hoping that the guys that are having serious problems really get to understand this stuff, because if anything, you getting into the trust side and learning that, making your claims on that side, it's going to help a lot in their cases. Sometimes, of course, you might be in jail, you know, and it's unfortunate, but that's the system we live in. And the best thing to do is not to rebel. You know, don't rebel. You know, they want money. If you ain't got it, well, you just have to make that plea. But if you do have it, pay it and keep learning. Because what's awaiting for you is much better than the citation that you had to pay. But anyway, that's my take on it.
This is out of 89 CJS, Section 42. This is a declaration of trust. It says a sufficient declaration of a trust is essential to the creation of express or voluntary trusts, which generally are created by an instrument or instruments pointing out directly and expressly the property, persons, and purpose of the trust, or by an agreement or contract expressing the intended trust.
Very simple, isn't it?
Yes, it's simple.
So in actuality, they're not really requiring you to have a full-blown trust document.
If you put quote unquote declaration of trust unquote, that right there, I'm looking at a case site that says the case decided that the instrument to be a declaration of trust must appear to have been so intended by the maker. That's intent. Just that right alone, if you just put in there a declaration of trust, that demonstrates intent. The intent of the maker, the grantor, intended to make a trust. There's no question about that. Right there, that fulfills one of the elements. Intent.
I had written a paragraph dealing with my equitable rights, and I know that helps in at least making your attempt, isn't it?
Well, it goes on. It says that the maker's intent can be demonstrated or manifested by their words or their actions. So you don't have to have specific words that demonstrates an intent to form a trust. You can do it just by your actions.
Yeah. And that was CJS 89?
Yeah, CJS, yes. Book 89, CJS, Section 42.
You know, I've been leaning on you for... Go ahead.
It says the declaration must, and I stress the word must contain sufficient words to create the trust. And it must, and I stress must again, embody all the essential elements of a trust. If you are missing one of those elements, you do not have a trust. It says it must embody all the essential elements of a trust. It must express the intention to create a trust, as discussed in Infra Section 43 through 44, and state with certainty the terms, subject, persons, and object of the trust. And it also has been stated that the trustee must be authorized and directed to perform certain duties and assume certain obligations. The trust is not created unless the settlor imposes enforceable duties on the transferee or the trustee. A trust, whether of real or personal property, is created as to the trustor and beneficiary by any words or acts of the trustor, and that's the grantor, indicating with reasonable certainty and intention on part of the trustor to create a trust and the subject, purpose, and beneficiary of the trust.
Very well spoken, Christian.
Well, that's quoting right out of the book. I'm just quoting what they write. Go by what they write, include in there what they write, and the law must recognize this to be a trust. Then if you've got a trust that the law recognizes to be a legal, valid trust, then you're in equity. Because that's where trusts live, equity.
I was noticing in one of our trust sites, where can I find the online, of course, the complete set of what you've been teaching us on CJS?
The law library. They got 170 volumes of this. Every law library has got 170 volumes of corpus juris secundum, or as many volumes as in their set.
Well, I was hoping that you may have known of a site, that any of us can, go down and open up.
Well, if people have room, I suggest they start checking around with some of their local attorneys and see whether or not they're getting rid of their old sets, because they do that. And you can purchase a whole set for probably less than $200.
Oh, well. I'll just keep digging. I know that CJS has to be posted somewhere on the internet.
Yes, we are having people copy them, but
a lot of work.
Yeah.
Yeah, and I applaud those people that copied them. That takes a lot of your time and energy. But what I've just noticed, what you have said from the last 5 minutes, is that sometimes you have to take a few steps backward and look at the material that we went through, because when you start actually getting active and do something about your situation, it's good to know the foundational material and embed it into your brain. Unfortunately, I don't have a brain. Somebody took it.
No, they've just been feeding you bad propaganda. Yeah, just have to unlearn that stuff.
Thanks, Kristen. You just don't know how much help you just gave me. I'll keep you posted through faith, and let you know if it all rang out real well.
All right.
I'll digress. Let someone with real problems come on. Thanks, man.
It says here under Section 40, Execution and Delivery of Book 89, CJS, since a trust may be created and declared by the same person, or it may be created by one person and declared by another. The declaration of trust made simultaneously with the acceptance of a legal title. Right then is where the trust forms. Acceptance of the legal title being, say, trust res. We still on? Hello?
Oh, you know what? I think my headset got pulled out. Here I was asking you questions and you started talking.
Can't hear you.
I was just going to say, I hope that you get your phone service back up quickly.
You know, I'm watching the red lights, and I don't see anything yet.
Yeah.
Still blinking dead.
Well, folks, if you got anybody has a question for Christian, hit star 8 on your phone, and I'll unmute you, give you an opportunity to ask a question for Christian. And if not, then we'll go ahead and take a little break until next Wednesday night. By the way, Christian, I did get about 3 pages into the Practical Treaty and Law of Trust. We made it to page 507. So make a mental note of that, and we can start up next Wednesday on page 507. We do have another caller with a question. I don't know if I'm going to say this right. ZyQ, you've been unmuted. Go ahead with your question.
Oh, hello, Christian.
Hello.
Hey, I just have a quick question related to the bankruptcy issue. I wanted to go back and cover over some of the issues.
This Daryl?
Is it still a good idea to go ahead and use trust to extinguish debt related to bankruptcy?
Yes, that's the only way.
Well, that's what I'm thinking. I was called by a friend today who said that we should reconsider our position and do it by debtor-creditor, that was a better way to do it, but I don't know what that statement's based on.
Well, here's my argument against that. Anything in the debtor-creditor realm involves a negotiable debt instrument, and a negotiable debt instrument is created to pay another debt. So you're paying debt with debt, mounting debt up, and adding to the problem.
Exactly.
So I can, once I got that firmly fixed in my mind, I could no longer see doing debtor-creditor realm at all, period. Because all it has to do is, if I create that debt, I got to come back in on a trust and extinguish it. Because the only way you're going to extinguish it or get rid of it is really by merging the debt with an equitable asset and merger under trust. So why should I have to go out and create debtor-creditor stuff at all?
Exactly. Well, the argument was that the judge would be extremely harsh on anyone who was coming in to express a trust dealing with a bankruptcy. And my comment was that we've only been reading and doing this, 9 months or so?
Right.
Where do we have the statistics of people going in expressing a trust in the bankruptcy that would give us that kind of information that it's better to use debtor-creditor?
The bankruptcy itself, under Title 11, which is a statutory trust, and you're coming in under a statutory trust and you're doing a merger of titles and extinguishment of the debt.
Exactly. In my mind, it's the best road to go.
Say again?
I say, in my mind, it's the best road to go.
Merger trust, yeah. Titles, yes.
Exactly.
Now, I don't like the idea of coming under a set statutory trust and going by what they say their rules are, because that's what you're doing. You're agreeing to form a trust by contract, because when you go in there, you agree to abide by the rules established by this bankruptcy to be Title 11.
But can't you change it into, convert it to equity once you get there by invoking equity?
Yeah, I would have to take the case and turn the whole case into another, pull it out of the Title 11 statutory realm and then, turn it into a private trust.
And would you do that by merging any or all titles related to the case and doing the whole process?
Right. Now, I don't think they're going to like that, just what the fellow said.
Uh-huh. So,
but when, it's like, I think it was Standering who wrote in his paper when we were talking about admiralty, you know, he's in his article that he wrote, "Are you lost at sea?" And that C is the letter C. And that letter C is in admiralty supplemental rules, which means arrest. So are you lost in arrest? And in that article that he wrote, he said when the judge told him, "I don't want you to go there," he said in that article, he said, "I knew as soon as you said that, that's exactly where I want to go."
Where he needed to be.
Yes.
Well, as far as the titles, now, for example, in this case, the lawyers from one of the creditors has requested an immediate hearing to squash the bankruptcy, and has put in two motions: one to dismiss the bankruptcy, and another one to I can't remember what the other one was, but there are two of them. Now, can those be debt titles that can be merged and sent back to the trustee to be extinguished?
Yeah, because everything is a debt title they're trying to get you for repudiation.
Yeah. So would that be part of the process of converting this from a Title 11 case into a case in equity bankruptcy?
Yeah, be encompassing all the bills that they're going to throw at you and just put them all in one big pile. Those are all the debt titles. Put your equitable asset signature on those and give it back to them merged.
Uh-huh. And that should go back to the appointed trustee, Ms. Babbitt?
Yes, uh-huh.
Okay. All right.
With the instructions on, yeah, just like we've been talking about, I'd have the records of formation and who's the parties and everything, be able to prove a trust.
Mm-hmm.
And then the trustee's got the bills that need to be extinguished, and they've been merged with your equitable asset, and all the trustee's got to do is really ledger it.
Uh-huh. Okay.
Give them the orders along with the instructions, and then hopefully they'll do what they're supposed to do according to the duty, or else you're going to have to come in with a breach of trust.
Mm-hmm. Now, should we produce a memorandum in law stating all of the elements of developing a trust and all that?
Yeah,
stuff?
that points out to them that you know what the law is that is required, and here it is, and now there's no way around it.
Yeah.
So it's more or less, okay, it's like a game. It's like they play the game because they don't really know that we know, and the only way is going to be if I put the rules in there and show them that I do know.
Right.
And that's not to say they might still try to do something, to force the issue. But, sometimes you got to do what you got to do. Sometimes you got to stand on principle.
Right. But doesn't the judge, isn't he supposed to behave or act on the law and not based on his whim or whatever? Right.
So if they're trying to bring in statutes and codes or non-equity, let's put it that way, then this is a suit in equity, and all that doesn't apply. And I would point that out to them. That all that other stuff is frivolous. Does not apply. This is not an at-law side case.
Right. So now, to bring it into equity, would a motion need to be put into the court, or can that be done verbally at the hearing?
Well, you can do everything verbally, but I would follow it up with motions and writings.
So instead of sending all of it to the court beforehand, go to the hearing and declare it an equitable hearing?
Yeah, what's the next hearing? Is that on their motion
It's the 5th of October.
What's the hearing going to be on?
Well, that's the hearing will be on the two motions that the one of the creditors has put in for one to disallow the bankruptcy, and the other one, I can't remember what the other one was, but it was similar. In other words, they're wanting to say that this person can't do bankruptcy because X, Y, Z, and we don't think he should be allowed to do bankruptcy. What they're saying.
What are the reasons? Why are they saying you can't do the bankruptcy?
I don't have the motions in front of me. I'm at the farm and they're in town. Maybe if my brother will get on the phone, he can read them to you. He's listening, or should be. But off the top of my head, I can't remember exactly what all the arguments were for the cancellation of the bankruptcy.
Probably because you claim equitable interest.
Yeah. That was one of the things that was issue with the lawyer. He kept asking, "How are you going to pay this bankruptcy? How are you going to pay? You've got to have a payment plan." And my brother kept telling him, "Well, this is going to be in equity. It's equitable. There's no value. It'll be paid by equity." But the lawyer never could figure out what that meant, and he put in a motion to be excused or removed as counsel on the bankruptcy.
Okay. What is your payment plan?
Well, I don't know if he has one.
Maybe that's what you need. You need a colorable payment plan.
Okay. So, well, that'll be easy enough to come up with, won't it?
Yes. Just tell them the payment plan is to pay the debt with the equitable asset.
Well, that's what he told him, but this guy didn't understand that.
Okay, but it's probably not in the form according to what they can see. That's probably what the problem is. Because you got to have in bankruptcy, you got to have a payment plan put down on their form. Put that payment plan down on that form.
Oh, okay.
And then bring that into that hearing.
Well, I do believe that was one of the arguments from the people who were wanting the bankruptcy terminated, was that there was no payment plan or something to that effect.
Give them one.
Give them one.
I would assume that some of the stuff that they are telling you is probably true, So make something up to comport to what they're looking up to see. Because I remember in a bankruptcy that we were into that you have to have your bankruptcy payment plan on their forms.
Or they'll kick it out.
Yeah.
Okay. Very good.
So you're going to have to play in both realms at once. So you're going to have to play by their rules over there on the public bankruptcy side, and then simultaneously run this private equitable trust payment.
Okay.
Yeah, but all you have to do is probably put it on their form. Then they have to prove it though.
Yeah.
That's the next thing.
Well, now if you put on the payment plan that it's going to be paid through equitable means, that lawyer didn't seem to understand what that meant. Well,
yeah. Because those lawyers are at law, and the only thing that they can see and are used to playing around with is the legal titles, which is the 9/10 possessory titles, and it's got nothing to do with the beneficial titles or the equitable titles, which is the real substance.
Right. So if you
you're operating in a different realm from what they can see or what they understand or what they know of. Although the judge should know what you're talking about.
Yeah. Well, is there a possibility they could kick it out before you get to go before the judge to bring it into equity?
I don't think that's possible. The judge would have to dismiss it.
Uh-huh.
And he probably wouldn't dismiss it until after he's heard the matters.
Right.
But yeah, you could always ask him, what is it we're missing here? What is it that you need? And we'll furnish the paperwork for it.
Yeah.
And then make it colorable enough that it fits their pigeonhole, what they're looking to see, but in the real world, in the background, you're running on the private side using
right.
issue the orders to the trustee to take the equitable asset and merge it with the debt.
And extinguish.
Extinguish the debt, yeah. Terminate the case and discharge.
Well, now, we got an interesting letter from one of the creditors, and it said that if the bankruptcy discharged your debt, part of the statement was, if the bankruptcy discharges your debt, you will need to return the property, or otherwise, how she said it, otherwise you will be responsible for the full debt. To me, that didn't make sense. If the bankruptcy, if you extinguish the debt or discharge the debt, is not the object or the piece of property, is it not paid for?
Should be.
And why should you return it if it's been discharged? What gives them the right to request the property back?
Well, I think they're probably treating it as that's the equitable assets that they want to exchange for the debt. They get the property, and whatever you owed then was extinguished.
Okay.
But that's not the equitable asset. That's just the legal title.
Right. The equitable asset is the signature that they have on a card at their financial institution, isn't it?
Yeah. Well, the thing that they're probably would be accustomed to seeing is the note and the security agreement.
Mm-hmm.
Those two, if you could merge them in one entity, that would end that.
Right. Now, does that need to be done on each of the creditors involved, or the people who call themselves creditors involved in this bankruptcy? Or can all that be pulled into the under?
That does not have to be a physical possession. It's just when you merge the titles. See, that's what people are not quite getting,
Mm-hmm.
Like possession, right of possession, and right of real property.
Yeah.
So I could say I possess it, but I don't have the right to possess it. So if I transfer the right to possess into the trustee and I take the security agreement, which is the debt, and merge those two in one entity, I don't care who possesses the note. It's been merged.
Okay.
So it's irrelevant who possesses the note. It's if I can merge the right to possess and the debt title, then I've merged the equitable asset and the legal title in one entity.
Okay. In the case where you have a mortgage on a home, would you take the the warranty deed and merge the title with it, or is it?
Yeah, the mortgage and the security agreement. Yeah.
And that would take care of that as well.
That's the debt title. Yeah.
So, would it be prudent to go ahead and merge all these titles of every case that's involved in the bankruptcy? Go ahead and do that process.
Yeah, get rid of them because that's the only way you're going to is merge them.
Okay.
Like a fellow was asking me the other night. He said, would I take all the documents in the case? And I said, yes, all known documents at the time, put them all on as debt titles, list them all as debt titles and merge them.
And would those merged titles be then transferred to the trustee?
Yes.
Okay. So she might get a shoebox full of titles.
Okay, it's back up.
So you're back online, eh?
Yes, we're back online. Yeah.
Okay, great. Well, all right, that's all my questions. I appreciate it.
Okay. Thank you, Daryl.
Thank you.
Thanks, Daryl. Hey, folks, we're going to wrap it up for the night. It's 10 o'clock Eastern Time. For those of you who may have had a question and weren't able to ask it, I apologize for that. But I encourage you to write your question down and be prepared to ask it either on Christian's Saturday night call or his subsequent Tuesday night call, or you can wait until Wednesday night again next week so we can continue our discussion on NTT New Trust Technology, making payments under trust, which is merging titles and distinguishing debt. Thanks again for joining us, Christian. Always appreciate it. And looking forward to getting back on the call next Wednesday night, 8 o'clock Eastern Time.
Sorry for the troubles tonight, but we had some good questions there. So
absolutely. Had a really great crowd of listeners tonight. Thanks, everybody, for participating. Looking forward to having you back on the call next week. Good night, everyone. Good night, Christian.
Night, Matt. Thanks.
You're welcome.